In this area, we're going to talk about equal employment opportunity law. Title VII of the Civil Rights Act of 1964, as amended, forbids job discrimination against employees on the basis of race, color, religion, gender, or national origin. Compliance with Title VII is monitored by the Equal Employment Opportunity Commission, which is the federal administrative agency that handles employment discrimination. Before bringing a lawsuit against the employee must file with the EEOC first when the employee has a Title VII claim. If a state EEO agency or the EEOC is not able to resolve the case, the EEOC issues a right to sue letter that enables the person claiming a Title VII violation to sue in a federal district court. An affirmative action plan is legal under Title VII provided there is a voluntary plan justified as a remedial measure and provided it does not unnecessarily hinder the interests of Caucasians. Title VII protects employees against sexual harassment in the workplace. Quid pro quo is a Latin phrase that often translates to mean something in exchange for something else, like something in exchange for job opportunities, promotions, or salary increases. Typically, employers are held liable for Title VII violations by the firm's managerial or supervisory personnel in quid pro quo harassment cases, regardless of whether the employer knew about the harassment. However, employers are only liable for hostile environment cases if the employer knew or should have known about the harassment and failed to take proper remedial action. Title VII prohibits employers from discriminating against employees or job applicants on the basis of race, color, or national origin. 42 U.S.C. Section 1981 provides protection for race or ethnic discrimination also, in addition to Title VII, and has no caps on damages like Title VII does. Employers have several defenses that they may raise in a Title VII case to explain differences in the employment conditions. Bona fide occupational qualifications reasonably necessary to the normal operation of the business is one exception, but bona fide occupational qualifications does not apply for race or color. Job-related professional developed ability tests is another exception, and then bona fide seniority systems is another exception to Title VII. In 1991, the EEOC brought forth a commissioner's charge against Hooters, claiming its hiring practices discriminated against them. Hooters allowed only females to be Hooters girls. The settlement said that that was okay, that was a bona fide occupational qualification. You had to be a female to be a Hooters girl, and that was not a violation of Title VII. Under the Equal Pay Act, employers must not pay employees of one gender a lower wage rate than the rates paid to employees of other genders for substantially similar or equal work. And workers over 40 years old are protected from discrimination by the Age Discrimination and Employment Act. The Pregnancy Discrimination Act of 1978, which amended Title VII, expanded the definition of gender discrimination to include discrimination based on pregnancy. The Americans with Disabilities Act includes disabilities such as alcoholism, blindness, heart disease, cancer, muscular dystrophy, cerebral palsy, HIV. The Americans with Disabilities Act prohibits discrimination against persons with disabilities, and a disability substantially limits a major life activity. Under the ADA, employers must make reasonable accommodations without undue hardship on them to enable individuals with disabilities to work. Employers who do not accommodate the needs of employees with disabilities must demonstrate that the accommodation would cause undue hardship, and it's determined on a case-by-case basis. Employers are not required to hire or retain workers who, because of their disability, pose a direct threat to the health or safety of their coworkers. Courts have generally held that AIDS is not contagious as to disqualify employees from most jobs.